All right. Hello, everyone. Welcome to another spectacular return of the Bitcoin Lore Review. I am, of course, your host, Tone Vays, and we have a much bigger house here today, and perhaps a few more will be joining us later on with lots of stories. As always, lots of legal action going on. We'll probably not even going to get to all of it today. We'll try to save a bunch of it for next week's show. So let's welcome once again Jason, Gordon, the lovely Sasha, and Bill Restis. How is everyone? Let's go one at a time real quick. Jason and Gordon, you guys were on the last show with us, so let's begin with Will. Will, tell us what's going on in your world. Very brief intro, and we go from there.
Yeah, Bill Restis Law Firm here in San Diego. I do complex litigation. It's mostly class actions and corporate governance, shareholder disputes. In the crypto world, it is ICO class actions and companies that want to talk about those issues. It's a pleasure to be back again.
Always a pleasure. Hey, we're going to talk about some of those. So I probably should have double checked if you have a conflict, but we'll find out when we get to the EOS ICO class action. I don't know if you're involved or not involved in that.
I'm not.
Okay, perfect. Excellent. All right, Sasha, let's head over to you.
Hi, everyone. Thanks for, tuning in. I'm glad to be on the show. I always learn a lot from the other lawyers in Tone and love discussing these topics. I work at DLT Law Group and Cogent Law Group lately, doing a little more work with them and focus primarily on money transmission issues or just general company formation. I try and stay out of litigation as much as possible. Thanks.
All right. Speaking of the opposite of staying out of litigation as much as possible, Jason, let's go over to you.
Good to see everybody. Specifically, I want to just take a moment to thank everybody in the Trollbox Hater Forum for all the hate that you bring to me every day.
It fuels them, guys. It fuels them.
If there has to be a voice that makes you get angry and sit up and type in the chair, I'm glad that it's me. I'll continue to challenge the traditional thoughts and dogma of the world every chance I can. But keep in mind, at the end of the day, my mission is to make sure that the world of Bitcoin and cryptocurrency moves forward in the best way possible. So you can hate me, but I'm here for you, whether you like it or
not. Nice. Hey, Gordon, how about you, man?
Jason, I hate you, but I need you. It's a complex cluster of emotions. No, Jason's awesome. Anyways, it's Gordon Einstein. Like everyone else here, just the attorney who focuses on crypto and blockchain. And I'm here to help the revolution happen, though the revolution seems to be running into all kinds of fun legal issues, which I guess is why we're needed. Tone, was it actually the last show we were talking about Telegram, or was that a couple back?
No, it was the last show. It was a while ago, but it was the last show because of the whole COVID stay at home and me being in Africa. But I want the show to really become weekly or at worst bi-weekly. So I am going to focus more on these types of shows. I'm going to be focusing a little less on trading. I want to bring this back. I mean, this is so important. And David Silver was right. Speaking of Silver, I'm hoping he'll join us when he says like the lawsuits and the regulatory hammers are about to start coming down. It's going to get worse.
It's going to get worse. And I think there's good arguments. Maybe we can discuss that here for jurisdiction selection and structuring like it's a war coming, because the key gloves are off. By the way, I thought you were in Uruguay. You're actually in Africa?
I was in Africa. I almost got stuck in Africa. I almost was still there. I flew out on the last flight before international travel was stopped. So 12 hours after my flight, it would have been over. That flight was packed. 16-hour flight, and it took me another flight to get to that flight. So that would not have been that would not have been good.
Well, I like your bunker.
Thank you. By the way, you can use it. So this is a lot of these are generic. So but I'm gonna be hating on people that are using backgrounds without green screens. Spend $150. You guys can afford it. Get a green screen. Really cool.
So on that note about upcoming SEC enforcement and litigation, one of the things that I'm going to be looking for, and that Bill and Gordon, as litigators, understand this very well, and Sasha, pay heed here as you start to get into this world, is that one of the things that are required in any complaint that alleges fraud is that fraud has to be alleged with specificity. Yep. This is a key component of any fraud case involving securities. And one of the things that I've seen in a few of the cases that come out is that the SEC is alleging generally that securities have been sold in the United States without actually naming any of the participants that participated in that. And I think with a lot of the ICOs that were focusing on selling to non-US investors, or were claiming that it was non-US investors that were to be impacted, I'm looking to see if the SEC actually takes the extra step to plead with specificity how they have jurisdiction if these investors were indeed extrajudicial. There was a case in 2010, I think it was Scalia that authored the case, that talked specifically about how sections of the Exchange Act and the Investor Act are not applied to international transactions, that they are only intended to enforce domestic transactions when the SEC looked to overreach their jurisdictions by going after people outside the United States or transactions that took place non-domestically. So this gets tricky. If you look back to the Tezos case, when Tezos looked to file motions to dismiss for lack of jurisdiction because they were a Swiss entity, the plaintiff in that case, and Bill, you may remember this, obviously.
I was plaintiff's counsel.
Right, you may remember this. One of the things that saved that is that the servers that Tezos were functioning on for their sales were located in Arizona. And that was enough to establish minimum contacts for the transactions that were happening domestically for those laws to occur. One of the things I'm looking for is if the SEC is going to actually start to allege where the servers were that handled these transactions in order to really specifically and plead and allege with specificity that jurisdiction as opposed to a generic statement. So those are some of the things that I've been looking at. I know it's probably not stuff for your normal viewers to geek out about, but from a civil procedure standpoint, in law school, first year civil procedure, jurisdiction was everything when it came to filing a complaint.
Well, I was going to nerd out and go down that rabbit hole, but I think you're right. That's a little bit
right.
Actually,
too fine a read.
Tone, with your permission, we should go down that rabbit hole because that specifically applies to operational security, OPSEC.
Yes.
You know, setting up your environment so that before you even end up in court, the deck is stacked in your favor, like having non-US domain names and servers.
Gordon, can you get a little closer to your microphone or speak up a little bit? There you go.
Really, I'm rarely accused of speaking
there you go.
Low tone, but okay, fine.
Start again back at OPSEC because I think the viewers probably want to hear that.
Sure, thank you.
So wait, when he says that, he means how to avoid the jurisdiction of the U.S. regulators and courts.
Well, I am partially saying that, and that's a facet of it. But I think a lot of crypto survivability goes to your legal and physical and operational structures that you set up prior to litigation or getting that in rem warrant on your wallet. And that runs the gamut from having domain names that are not generic top-level.coms and not based in the US, but having country-specific ones, having multiple ones, having failovers, but goes to your infrastructure, it goes to your jurisdiction selection. And I think that, Jason, to your point, jurisdiction and procedure is a huge chunk of it, and we should address it. But I think there's many facets of it that are real, and it's worth discussing for Tone's audience.
Well, there's more than one, right? So there's, if you want to avoid liability or minimize your liability, you want to think about jurisdictional issues, right? What laws can apply to you if you take certain active steps. And in a digital world where things are over the internet, where those steps occur, physically, where the physical equipment that manages those electronic transactions is relevant. There's a flip side to that though too. If you're someone who's transacting in the crypto space, you want to generally make sure that you have counterparties that are in a jurisdiction that is close to you. So for example, in the US, if I want to buy or sell Bitcoin, and I know I said this on, the Happening special when we had Gemini here, one of the reasons I use Gemini, and this is because they're here in the United States. And if they fuck me over, I have someone to sue, and they have assets here. And that's very important because people in this space constantly, and I don't take these cases because they're hard, but I can't tell you how many calls people like me and David Silver and others get because they were interacting with some service provider that is incorporated in the Seychelles or Little Cayman, and it's a black box that you'll never be able to get anything out of.
So one of the things to remember is that even though you may set up your servers overseas, your entities overseas, et cetera, it's not a 100% bar to any action by a state or federal regulator in the US, because they will ultimately come back and make the statement that the reason all of those steps were taken was specifically to avoid US regulation. That's kind of the catch-all defense or catch-all counter argument that the SEC or a state would bring, is that purposefully doing things to avoid regulation in and of itself is indicia that you're trying to do bad things, and therefore the SEC should have jurisdiction. But if you go back and read the case, and I'll go and look it up and bring it up later, and I'm drawing a blank on it now, that in and of itself, just being extrajudicial is not dispositive to be able to maintain jurisdiction.
And also think about your first argument that the fraud needs to be pled with specificity.
Specificity, that's right.
Okay. So they can allege that, but if that, that's the mens rea, right? That's your point. If they're making allegations regarding your internal mental state.
Yeah. So the thing about specificity is, let's say you had 10,000.
Specificity means facts, right?
Yes.
It means factual details, not to say somebody did something bad. It means this is how they did something bad. It's the who, what, where, why, and how of the bad thing that you're alleging occurred.
So sorry, I mixed two things when I just spoke there. So merely on the pleading requirements, the Jason's specificity argument, if his point is that the SEC has kind of gotten away without having to name the actual parties in the US that engaged in these transactions and got cheated, then you want to make it as untenable as possible for them to actually make that allegation and prove it.
Right.
Is like one half. And then the other part, addressing it separately, is when you set up your infrastructure offshore, that's, I guess, you can kind of intuit, and I understand that they can say that circumstantially points to your intent to avoid the regulatory reach of the US. We can easily flip that argument by saying, no, we're actually respecting it by not touching you guys and operating outside of the jurisdiction. It's a, it's not a perfect analogy, but it's a Reg S type situation where we're distancing ourselves from you guys because we don't want to break the law. It's
right.
Exactly opposite.
So one of the things when talking about pleading with specificity, and what I've seen in a few complaints that the SEC has brought forward, is that they have no problem saying that, say, 5,000 investors, and they're going to claim everybody's an investor, whether they were buying for utility or not, but everybody's an investor, and that there were 5,000 investors, and they violated US securities law. So every single transaction is in violation of that. So full disgorgement of everything needs to occur to the SEC, making up for ill-gotten gains from all the transactions. But what the SEC doesn't do is actually disclose how many of those 5,000 investors were actually in the United States to the extent that the SEC has jurisdiction to enforce those claims for those people, versus how many of those 5,000 were extraterritorially, where the laws don't apply and that the SEC shouldn't have jurisdiction to enforce disgorgement over those people. I would like to see a pleading standard where the SEC actually has to say, out of the 5,000, there were 1,285 of them that were in the United States. As such, we're enforcing the securities laws for those people specifically. We have evidence that out of the 5,000, there's 1,285 that existed here in the United States that were impacted, and that's what we're getting at.
So the long and short of it,
done it.
Jason, is you seem to be saying that the SEC is taking shortcuts and not
Yes.
meeting its burden to prove its cases, right? And that the courts are letting them get away with it.
Well, it's whether or not the courts are letting them get away with it, or whether defense counsel isn't thinking it all the way through about specificity and the requirements and where the SEC's jurisdiction begins and ends, and are willing to make those arguments and stand up for that.
Right.
Because more often than not, you have defense counsel that just wants to settle and be done, because making those arguments means if you win, it goes to appeal. If you lose, you go to appeal. And so these become defense costs for the people that are having to defend these claims on whether or not they want to go down that road. I would like to see the SEC be held to that, to only be able to stand up and be champions for the United States, which they should be. But the SEC's job isn't to protect somebody in Australia. And they're subsuming all of that into their
demure territory, correct? You're not, yes?
I'm sorry?
Yeah, I'm not Mr. Super Litigator. This is, what you're talking about would be, if I was on the defense, I'd be filing a demur, correct?
Yeah, you're basically filing motions to
insufficient.
dismiss for lack of subject matter jurisdiction. Yeah.
Jason, what did you think? It wasn't the SEC, but in the BitMEX lawsuits, but the two more recent ones, they really went to great efforts to prove that BitMEX has contacts in California. They listed, all kinds of vendors that they were using in California. They showed a picture of Arthur Hayes with supposedly California in the background. I think it was a virtual background, but they said, "Oh, look, he's there making a video," And
so the difference there is that's plaintiff's counsel versus SEC.
But do you think it'll stick? Like, where is the line of what actually brings someone into the U.S.?
Well, look, I can be in the United States and I can run an ICO, but if my company is offshore and my servers are offshore and all the transactions happen offshore, it doesn't matter that I'm in the United States. All of the transactions are extraterritorial and they're not domestic.
What about an employee or 20 employees in California?
All of this becomes fact specific on where the transaction occurred. See, securities all are dependent upon the time, date, and location of the transaction, and whether or not you can argue the transaction occurred at certain date and time, and then what statements happened leading up to the transaction upon which were relied upon, what may be a continuing fraud or not, but where was the check written or where was the money given, and where did it go to the extent that that interaction occurs. So all of these things are going to be fact specific for all of these cases that started this conversation, which was the SEC's bringing the enforcement even more and more this year.
Hey guys, can I just, I want to jump in this. I do want to move on to our stories, which are really, really good, but this is a very good discussion. And I can't let it go without asking a specific question. While you guys are focusing on the SEC and the plaintiff and mostly the defense, what does this mean for the person in that jurisdiction? So that's my last question. So basically, in the example that you gave, Jason, you want the SEC to name names of those people that say bought an ICO out of the US. What does this mean for that person? Like, this is just like some guy at the computer who may or may not have even been 18 years old, or perhaps an adult, at least by age, to buy into the ICO. What does this mean for the majority of the people watching this channel?
Well, here's where I approach this, right? If the SEC is going to bring a claim that I've committed securities fraud, you better show me who the investor is, tell me when they purchased it, tell me at what time they purchased it, so I can cross-examine them, look at their accounts, verify whether or not they actually purchased it or not, and then look at the statements you're alleging are fraudulent, and did those statements occur before or after the guy purchased something? To the extent that you're claiming I made fraudulent statements, if the statements I made happened 3 days after the person purchased it, I can dismiss that claim, right? It's all time-based.
For you, Tone, and really for the people who are watching that aren't lawyers and they're investors or whatever, or utility token users in in the space.
I will always take the position that none of these tokens have actual utility. If anyone
for sure, don't get
they
me
do it for
started on that. We're going to talk about the Telegram case, but the law of a jurisdiction is like an umbrella. Okay, you're outside and it's raining. Okay, so the law, you're either under the umbrella, which means the law applies to you, or you're outside of the umbrella, which means the law does not apply to you. And usually that umbrella, if you were to hold it over a map, if it's the law of the United States, will be an umbrella the shape and size of the United States, right? And it can affect
the planet.
It can affect either the people that are inside the United States, right? The people who had actions directed towards them, or people in the United States can't. So you could have people in the United States that had actions directed towards them from outside the United States, and it's affecting people within the United States. So the umbrella applies to those people. Or you have people, the converse of that, and I'm just talking now, and I'm forgetting which one I said. But it really depends on where you are, and man, I lost my train of thought right on.
Well, I think you're trying to say there's a matrix. Both parties, just assuming there's two parties, both within a jurisdiction. And there's the matrix where I guess from the U.S. perspective, the perpetrator's inside the U.S. and the recipient is outside.
Correct.
That's not so much our concern. Then there's the reverse, which is the challenge, which is when the perpetrator's outside and the victim's inside. And then this final one is when both parties are outside the United States, and does the U.S. have jurisdiction at all?
Mm-hmm.
So using it,
and that's what lawyers deal with every day, right? At least, and at least that's how jurisdiction works inside the United States. But it's something that when you're crossing borders and you want to make sure that you have, I know in crypto we love that everything is self-executing. You can create, contracts that are self-executing. But at the end of the day, there's some situations where there's counterparty risk. Mm-hmm. And when there is counterparty risk, you want to know what jurisdiction that counterparty is in, because it will affect your risk calculation, right? It affects your discounted risk analysis of what is required for you as a return to make up for the risk that is being impregnated into the transaction that you're about to take, if that makes any sense.
It does. I think that analysis is impacted or skewed by the legal risk associated with touching the United States, and that's a countervailing value, which may not be sufficient to overcome the issue of do you trust your counterparty. It's a tough analysis, and I think you alleged to an interesting point, which is to the extent we can automate around this or as smart contract implementations that offload some of this counterparty risk, the incentive to be outside the United States will increase, but I don't think we're there yet, which is what you're saying.
All right, guys, let's jump to a specific.
I found the case that I was talking about before we go on to there, and I posted it in our individual Telegram group for the Law Show. But for those watching, the case that I'm talking about for domestic versus extrajudicial transactions is called Morrison versus National Australia Bank, 561 US 247, decided in 2010.
I'll put it in the video description.
There you go. And it was decided by Justice Scalia. And this does an amazing job of going through the older tests for determining domestic versus extraterritorial jurisdiction versus not. And I won't go into the details here, but when for any of the attorneys that are watching this and you're considering your clients and if they've had US versus non-US participants in an ICO, I highly recommend reviewing this.
The Morrison case is fundamental for sure.
It is. And I haven't seen anybody in the ICO world bring up Morrison in defending their ICOs and holding the SEC to the standard of verifying that. Now, I'm sure, Bill, you talked about Morrison in Tezos and saying that the transactions happened here in the United States, that the money was given here based on the server location, et cetera. but I haven't seen the counter argument from a defense
Right,
saying
because
that
that's one of the things we've seen, and I don't, just cut us off, Tone, because we'll just go down this rabbit hole forever.
Well, no, I mean, like, I'm more tempted to cut you guys off. This show, the last thing I want for this show to become is how do ICOs can defend themselves better.
Well, no, don't look at it that way. Don't look at it, how can ICOs defend themselves better? I look at this as how can a citizen defend themselves against an overreaching generalist government that's trying to exercise powers that haven't been delegated to them.
I know, I agree.
Oh, yeah.
I agree,
Right.
but then how do? But in that case, then Bill and David Silver aren't doing a good enough job getting after these ICOs with class actions, right?
No, that's not a Bill and David Silver problem. That has nothing to do with Bill and David. They allege their complaints perfectly fine. This has to do with the SEC. So
I know.
You know.
Well, because I think the reason why we're talking about it is because if you look at the way all of these ICOs were structured in 2016 through 2018, they tried to internationalize it in a way that got it outside the reach of the US regulators and outside the reach of the US courts for private plaintiffs. And in some situations, I think as a practical matter, they did, and in other situations, they didn't. But that was part of the structural design, was people who thought that they were smarter than everybody else, that they could create a Rube Goldberg device, a legal Rube Goldberg device that suddenly would put them in this regulatory black hole where no law applied to them. And that was frankly what I think is borderline malpractice. And I think we're going to see some malpractice cases by ICO issuers against their counsel who sold them these what are now steaming piles of poo from a legal perspective.
I don't disagree, but that doesn't forgive the SEC's burden to have to plead with specificity and to actually plead their jurisdiction. So with that, if I can have the last note on that, because don't get me wrong, I am all for proper enforcement. I'm all for things not being scams, but I'm also all for holding the government to be limited in their power to what their power has been delegated to without them
I agree.
running to the courthouse. So
I agree with you, Jason, but like these ICOs are, many of them are out of control. We're going to talk about some of them here on the show, hopefully. All right, so let's move on. So speaking of an ICO that I actually felt wasn't out of control, unlike the rest that we will discuss, this is the one that we discussed at length here last time with Jason and Gordon. Just as a follow-up, did they settle? Is this completely over? I'll give Gordon the first say on this one because you also sent over this article from Pavel Durov himself, where he's saying what was done and why it's over. So is he conceding? Is this case coming to an end? Are they settling? What's going on?
Yes, he's conceding. He shouldn't, but he is. And to a certain extent, he's reimbursing money and either a small discount or a slight markup. And he, as far as I can tell, threw up the white flag, and maybe the code's going up on GitHub. Maybe other people are going to launch networks based on this technology. But his general argument or statement in this blog is the United States is jealously guarding its centralized power, and the very act of guarding it is preventing the decentralized systems from arising that need to. And that even though he's, I guess Telegram is based in Dubai, they, given the current state of the world, can't fight this battle. I'm kind of surprised. I mean, this is the guy who told Putin go to, where to stick it with, mail.ru and VK and everything else, but he's conceding on this. It's kind of a letdown, and I have a huge amount of respect for him and what he's accomplished. I also, we discussed, go ahead.
I would have liked to have seen this actually maybe in a pass the hat campaign through the entire crypto community, supporting the litigation, wait for an unfavorable result, have it go to the Court of Appeals, and have them determine whether or not a court, prior to any trial at all, can make a decision based on the assumption that maybe one day a US person might come in contact with one of these tokens in order to ban it based on the assumption that maybe somebody in the US would be affected. I think that's just so far overreaching that it just smacks of hubris, or I don't know. But I would have liked to have seen
it's
this
hubris. It's the assumption that if it happens anywhere in the universe, it may touch an American, therefore we can intercede. And I think the rest of the world's getting kind of sick of it.
It opens up every other SAFT issuer, I think, to to more litigation here too.
Yep.
Well, there's definitely an indictment of the SAFT structure. Whether or not there was edges that were shaved off in the government's burden of proof here is a very interesting question. But
the SAFT structure itself needed
SAFT
criticism.
was a terrible idea. It's been a terrible idea for years, and some court was going to make that determination. And what Judge Carter, not Judge Carter,
Costas or something.
Costas said is that you can't separate the issuance of the tokens from the contract that gives birth to the issuance of the tokens, which is the SAFT. And the court looked at the entire structure of the SAFT through distribution and said the people, and I don't know exactly how many it was, but it was a small number, approximately 100 private investors into the private sale, were essentially underwriters, and that they were acting as a distribution conduit for Telegram. And I think that analysis is a cogent one. Now, how that is affected by these jurisdictional issues is another question. And we all know that very good lawyers can get a case that is bad on the merits dismissed or overturned, particularly in federal court, because the chessboard is very complicated and it's very rigorous in the requirements that it sets. This is just a really quick aside about federal court is, you started this, Jason, talking about these procedural rules of pleading. Well, the best lawyers win their cases on the procedural issues or lose their cases on the procedural issues. And so you can take a case like this that is an indictment of the SAFT structure, which I think the analysis is cogent and correct. And you can ultimately get, if you have good counsel and good litigation budget and just a stomach for litigation, you can take a good case and have it not decided or dismissed or otherwise disposed of because there's a procedural issue which wasn't done properly.
So, Bill, I wish you had been on the last Tone Vays show where Jason and I went at the exact thing you're talking about for over an hour. And I completely disagree with you with respect to the tranche 1 Telegram investors. If you take with some, if you take the Commissioner Hinman presentation on Yahoo about Gary Plastics, I know that's not official SEC rules, but if you look at what he said, plus the way the SEC has treated Ethereum, I don't think it's ridiculous to think that something can eventually change its nature from being a security into something else. And just for the audience, I'm going to remind everyone that there were 2 tranches of Telegram sales. There was a second tranche, which was very sketchy, where the people who got a very massive discount were able to sell their tokens the immediate moment the network went live. That's very underwriter-ish, if you like. But the first tranche was highly restricted. They could not sell until the network went live. They had timed liquidations over time. I think they could only sell the first 25% 3 months in, then 6 months, then a year, then 18 months. At some point, it gets so stretched out in time with so many market factors taking place since the initial creation of the contract, that it's very hard to argue they're not an underwriter anymore. I mean, it's very...
The difficulty that you get is
not since the contract.
The difficulty that you get, and what the SEC presented and what the court considered, is separating out what had already become a conflated asset, right? You have these. So when you look at what the gram was, you had this SAFT agreement that said, give me X amount of dollars and on X date, you'll get so many grams. That in and of itself is a whole individual standing contract that has nothing to do with the gram being any type of investment interest. It is the contract itself, give me money now for grams later, that is the investment contract, right? Just like,
well, that was the theory. I mean, that's
right,
was
but that's what this court has done away with. And it's
exactly, and I think that that's correct.
I don't think
if
it
you
is.
zoom out, I mean, see, the problem is if you get down into the wrinkles of, and maybe that's proper. If you get way down into the wrinkles of this, you can argue about how many angels are on the head of a pin. And I understand that the securities laws are sufficiently nuanced that you can do that. And that you can come up with a decision either way because there's so many lines that have been drawn. However, if you zoom out and you look at this from 30,000 feet, which I think the judge did, and that's why I think that this is correct, that it is calling a spade, and that you can't use these. And we see it all the time. We see it all the time in the law where you can use these legal structures to separate risk and to separate liability into different parts of a transaction, and they're deemed proper all the time. But in this case, I think that both the SEC and the judge said to the lawyers, you got too cute. You tried to create legal fictions that didn't represent the realities of the transactions. And that's why you have the legal result.
Maybe, but I think when
can we dive into this?
Let me finish this up. As Gordon talked about, if you look at the Hinman analysis and the Gary Plastic conversation, what they were talking about, and even through admission, is that the ICO SAFT agreements in the Ethereum sale, those themselves were more likely than not investment contracts. And I think we can all agree that those were investment contracts. But where Hinman wasn't willing to go was to say that the actual ETH that was associated with the delivery of those contracts was the investment contract. And from that standpoint, I can come up with all kinds of analogies of similar type commodities type things that step outside of the SEC's jurisdiction and have nothing to do with an investment contract, but are the subject matter. That would be like saying in Howey that an individual orange is a security versus the investment contract, which was the management contract for the sale of the property.
I get it. I know.
Right.
I
so,
get it.
Maybe, yes, maybe they got too cute in the tranches. Maybe they made mistakes in that. But I think it sets a terrible precedent that the SEC is going to push, that every single underlying token,
I don't think
regardless,
so. And
is
if
going
you
to be an
look at the
investment
judge's
contract.
opinion, if you look at the judge's opinion, and I don't know, Tone, whether you can do this, it's in the first paragraph.
We had it brought up on the last show.
Yeah,
Right, yeah.
it's probably on one of those tabs up there.
Oh, I mean, like one of these
The
tabs.
judge's order granting that's the complaint. The judge's order, there it is. So if you go down, I think it's page 2. It says right here, first paragraph.
Using the Howey test.
Cryptocurrencies, right? The first sentence of the full paragraph there, it says cryptocurrencies, sometimes called tokens or digital assets, are lawful means of storing or transferring value and may fluctuate in value as any commodity would. In the abstract, an investment of money in a cryptocurrency utilized in the abstract. The investment of money in a cryptocurrency utilized by members of a decentralized community connected by a blockchain technology, which itself is administered by this community of users rather than by a common enterprise, is not likely to be deemed a security under the familiar test laid out in Howey. And so I don't think the overreach is there. I think that it's pointing out the specific structure that was used as the mechanism for the offering. And the judge said, I can see through your bullshit. You're trying to separate these things out when they're really, it's one transaction, when you're trying to make it look like it isn't.
All right, so let me add, look here, same hypothetical as last time, if you don't mind going down this road. I mean, suppose that, forget tranche 2, because they clearly screwed up. That created the opening. But the tranche 1, if they had their token purchase agreements and they had to wait to sell their tokens or even receive their tokens until 5 years after the network launched was being used, would you say that those tokens are tainted by the original source and are securities forever?
Yeah, I don't know. I would have to think more carefully about it. I think you're right that it is a different factual scenario.
I would argue that they're more like securities at that point. I would say that they're more like securities because they're being locked up, like as though there's some stock.
Yeah, why would you lock them up if they're not securities?
Right. So that's why I think this lockup period is harmful.
Give them time, because we agree with Hinman that these things can change their legal nature based on the network becoming sufficiently decentralized and these tokens being usable. Yeah. So but while these things are
but here's the problem is this was really trying to build on an extension of one sentence in the Foreman opinion that said that something that is used for consumption, and I don't remember the exact language of it.
It was like saying that a house or whatever.
Right. Okay. So there was this one sentence in
Foreman. I now have Foreman permanently as a tab because you guys constantly reference it.
Okay. So there was, and this is important because Foreman was the Supreme Court opinion, and I'm not going to go into too much detail, but it had one sentence in there that said if something is used for has a consumptive purpose, as opposed to an investment purpose, then it's not a security. Okay. And from this one sentence was extrapolated this idea that you could create a utility token. This was the foundation of the house of the utility token argument. And I got to be honest with you, it's a really thin, it's a weak foundation. And so
let me take that one apart.
Wait, there's also, Bill, the Foreman opinion, and in a like completely different matter on FinCEN's side, which I know is separate from the SEC, but there's also the idea there, it's written out pretty clearly if something is used for a good or service as opposed to just money transmission. So I kind of look at them a little bit similarly on the securities side if it's used just for an investment purpose. But if like look at Tesla's truck offering, you know, that was kind of an ICO that they did, like you can pay $100 and get pre-order a truck. But everyone, or I've heard it a lot, the analysis of if it's for a car or something tangible, it's not a security. And I think that does, like that, there has to be some distinction. So that's a pretty
that's the Kickstarter and Indiegogo business.
Mm-hmm.
Well, okay, so look, what the court did is they kind of adopted the California's risk capital test, which is if you're buying something prior to it being built and it may not actually be built, for example, a gym membership or country club membership, then you're sort of co-venturers along with the founders and we're going to treat it like a security. But California never said after the gym or country club is built that those memberships are forever more securities. So even if you do—
Nor should they be. But I guess my point is that they built a house, they built a house that was way too big to stand upon the foundation that existed. And now we're seeing that the winds have blown and the structure of that house that was built has toppled over.
I'm missing the legal argument.
Following the analogy.
Well,
regards to what?
So when you argue for an extension of the law, which is effectively what these ICO issuers were doing by operating in the United States, they were looking for a way that they could say, you know what, we don't want to be subject to the securities laws in the United States. We want to be able to sell these tokens to U.S. persons or from the U.S. to international persons. And we don't want to be subject to these, the penalties, the disclosure requirements, the costs and obligations that go along with that. So how can we get around that? And their lawyers, you know, they sat around, they scratched their heads and they went into their law books and they said, okay, well, we've got this consumptive test here in the Foreman opinion. It's a Supreme Court case. I think we can expand upon that. And so this concept of, you know, the utility token concept was based on that. It was based on trying to get around the application of the federal securities laws. Now, whether, I'm not saying that's a good thing or a bad thing, but this whole concept that these laws could be avoided were based on a very small, a very thin reed. So when you built something on top of that, That's the house analogy, which is the ICO structure that was propagated.
Now, I want to.
It just didn't have the ability to withstand.
So
let me please.
Let me just. I got to defend utility tokens for a second. So very early on, in 2015, I started working with folks as how their various cryptocurrencies or projects could operate exclusive of securities laws. And the concept was, if you're doing something other than investment purposes, if it has some functionality other than investment purposes, and that can be the primary purpose, there's no reason why that asset itself should not be considered a utility type function. And that went back to the old counterparty assets and the various things that people were doing, such as digital art with the rare Pepes. And I know a lot of people remember rare Pepes. But
it's very outright of you.
Right, go ahead and look it up. But there were a lot of concerns on whether or not a rare Pepe would be looked at as an investment contract. And the argument is no, it is digital art for consumption and purchase. And that makes it a utility. And so if a rare Pepe can be used for consumption or created and sold for consumptive purposes, that means an ERC20 token can as well, if the primary purpose is for that. Not every utility token and not every asset has to be created as a utility token in order to run some scam.
So I'm not saying there's no such thing as a utility token, but I'm going to tell you
there's a lot of people that have said that over the years. There's a lot of people that said that.
And I'm not saying
including Tone.
I've said that.
Right? But Tone, would you say that a rare Pepe is a utility token or not?
The way that it was executed in these ICOs was it was a wink wink. They would put it in the contracts, they would put it in the SAFT, and they would put it in the terms and conditions that said, this is not an investment, wink, wink. You're not doing this for any investment purposes. You're doing it because you want to consume them for whatever purpose.
And so they were playing fast and
agreements are clearly investment contracts. I think we all agree. Yeah. The fundamental question is every product of an investment contract always and forever going to be an investment contract or security itself? And I think there's fantastic.
No, but we're not looking at good examples. These cases, like the Telegram case, it was trying.
I disagree.
The
first tranche was a good example. Waiting until the network launches plus that extra period of time. I mean,
it was a test. It was a test to see whether it would fly in the courts, and the SEC didn't buy it in the court, and the judge didn't buy it. And I suspect the reason why they're not appealing it to the Second Circuit is because the Second Circuit wouldn't buy it either, especially not on these facts.
On these facts, I'm being careful to separate the two tranches. Okay, I am saying Telegram made a mistake with the terms of the second tranche. They opened the door and they got whacked. Okay, but if they'd stuck with the first form, which is after network launches and the tokens have utility, you then have to wait additional time. So you're not merely making money on the markup between your purchase price and the immediate sale of the public price, but you're now just market fluctuations. The thing either has utility or doesn't. Okay,
the judge
by itself is not inherently wrong. Let me just point out one other thing. With Foreman, let me just get this out. With Foreman, okay, the idea that you could rebut the presumption of security if it was a consumable was, I think, specific to Foreman in that they were selling something labeled as stock or labeled as shares, but really when you unpacked it, did not have economic and legal rights associated with shares. They're just access to housing. So they said, we're gonna do substantive reform, and we're gonna look at the economic essence of what's here. We see that it's a consumable, therefore we're gonna disregard the label and treat it for what it is. But that's not necessarily like tokens, because tokens are not traditional securities types. We have to disregard the form to go for the economic essence.
Well, I think with any analysis of any asset, whether or not it's a security, the SEC claims that everyone is going to be looked at on a fact-based scenario. And I wish that was true. And I hope that moving forward, they would say that that's true. But my fear, as was exposed over the last couple of months, is that they're not looking at things from a fact-based basis, and they're looking at every single sale of every single asset ever from here ad infinitum is going to be a security right from the beginning. And then you're going to have to prove to them that it's not, as opposed to the other way around, that they are going to have to prove that it's a security. So there's a presumption of a security now with every crypto asset that comes out as a result of.
You know, I think what you're looking. Go ahead, Tone. You haven't got a word edgewise.
Okay. It's crazy. Like, for the first time in the history of the show, I don't want to talk about security law because we have other interesting cases like Ripple versus YouTube. I would love to get back to this. I do want to let Sasha say something, and then I'll just close this out.
Oh yeah, I mean, I think I agree. We've kind of belabored it, but in one of the responses by the judge, I thought her point was really, really good, saying, why would you pay $1.7 billion to acquire grams merely as a means of storing or transferring value? Like, you can transfer and store value a lot of different ways without having to pay 1.7. So the whole idea that this was a utility token, ever was kind of a hard argument to make when you have that kind of money involved with it.
Yeah, and I'm with you on that. And Jason did ask me a question earlier of what I thought of rare pepes. I thought it was stupid, but I never saw rare pepes as a violation of security laws, in my non-professional opinion, obviously. So to me, rare pepes was exactly like baseball cards. That's how I thought of them. Now, building them on top of counterparty, I thought was kind of silly. And the whole counterparty token is kind of silly. I didn't see the need for these ridiculous layers that don't actually bring you any additional decentralization. And as far as this Tron token goes, I was mostly upset that the SEC went after this project, because I could have named over 100 other projects I would have rather have the SEC go after. I thought the utility case of Tron to me was complete bullshit, and the ability to build a decentralized network with this token to me is complete bullshit. But at least they tried, to avoid US investors, and they also actually tried not to get, people from Twitter and Facebook to invest in this thing. And Gordon, I want to go back to something you said earlier. When you said, hey, because of the structure of that first layer, where they would not be able to sell this token immediately after it launches, and then they have to have tiers and they wait longer. But like you just said, that the purpose of that was to avoid them just profiting on the speculation of it. So if they are suspecting,
that was one of the purposes,
right? But if you are suspecting that is going to happen, and you have to put in stuff to avoid it, isn't it in the back of your mind as the creator of this? People are actually going to buy into this for speculation, and obviously not a utility. So now I got to put in all these.
It's a double-edged sword.
Okay, so let me
it's a double-edged sword. Yeah.
Just Pavel Durov's example in his blog, I'm putting up the screen, even though it's in your screen, is right. Okay, I may invest in a gold mine because I want to profit, but that does not make the resulting gold a security. And if dividends are paid to me in gold based on my stock, they don't become securities in my hands just because they came from my stock.
Hey, that sounds very familiar. Didn't one of you say this on our show last time?
I said it, and they freaking copied it.
Now you would concede that the difference here is that if you're constructing a gold mine today, gold is an established commodity with an established market, and is not likely to spike based on the new gold mine venture. Whereas in this case, with the issuance of a gram, it's a brand new commodity with a brand new market, with a wholly speculative environment where we have no idea where or what the price is going to be, and that getting into it earlier would then necessarily promote a price hike later. So I think it may, while I agree, and we talked about this, that I agree with the argument of the gold mine investment and that the resultant gold isn't there. Where this is different is that this is a brand new commodity, and so it may be a slight false equivalency when making that comparison.
Well, okay, I invest
that makes sense?
in a robot factory, and the dividends I get paid are cutting edge robots, which may or may not work and may have an uncertain market value in the future. Those robots, when they're finally given to me and I'm using them, aren't.
Is there a secondary market robot exchange that fluctuates based on things other than the inherent performance of the robots?
I think there's a secondary market for almost everything on the planet that's not entirely tied to the utility of the thing, but that doesn't turn into security.
I think we may have just jumped the shark on this conversation when we're
Well, sorry,
talking about
I gotta do one last
robots.
Tone, the
Yeah.
benefit of making it so that there was a delay between the network launch and the ability for these people to sell it was not meant to dispute the fact that they initially invested for a profit. It's meant to undermine that they're an underwriter, that they're part of the original distribution scheme, such that it was not coming to rest in their hands, but they were just a mere conduit to the public. Now, there's no rule that says once you buy security, you have to hold on to it for 500 years. We're all around, we're all allowed to turn around and resell stuff without being underwriters.
No, that's not necessarily the case. There are several limited and exempt offerings that require at least a 12-month lockup period.
Right, and that's what I'm saying. Telegram Tranche 1 had that, because between the time to the
Which makes it look more like a security than not a utility at that point. So
right, they are a utility at that point, and yet the SEC stopped it.
No. The point I'm making is if David was here, he would say if it walks like a duck, talks like a duck, it must be a duck, right? Because David likes ducks.
My argument to that is an egg can turn into a chicken. You don't say the chicken's still an egg.
Sure. So when, and this is always the double-edged sword, and I can argue both sides, and it's fine, and we can argue on the same side, and I can argue against it. The purpose of law in these shows is to moot it out and to try to find some common ground in the middle. But when you are designing your asset like a SAFT or anything else, and it has more functionality and looks more like a security than not a security, you are going to invite that scrutiny from the SEC and from the court to make it look more like a security than not. And I think in this case, the payment of their investment contract in the tokens themselves, as opposed to a repayment in fiat, makes the underlying asset suspect to be an asset that might be an investment contract. And two, by having a lockup period of time to where they are unable to use it, makes it look more like it's some form of locked up 12-month lockup period that equates to any other exempted type asset or investment. So it's or you can say no, it's a separate one. There's all of that's there, and the judge made the decision. I don't necessarily agree with it, only because I think that the SEC is going to take that far beyond the intent of the court, and they're going to argue it has a different meaning. But that's because I spend more time doing defense stuff than plaintiff stuff, and Bill will love it and David will love it because they'll be able to use the other side of the sword and say that everything that's out there is
listen, I
security.
am on both sides of this. I represent companies and I represent investors, so I can appreciate it both ways. I just try to look at it objectively. The Ripple class action is one. Now that Tone has this up here.
Yeah, I have it up, and unfortunately we have to lead into the Ripple story with the current Ripple class action. And I want to do like an entire 12-hour marathon on the Ripple being a security class action. And I'm dying to get into that, but on this show, we're going to move on to another one. But go ahead, lead us in, Bill, into the Ripple story with their class action.
Well, I mean, I've been following this, because this was filed back, I think, in 2018. And I didn't think it had a lot of potential for success, to be candid. I thought it had statute of limitations issues, not issues on whether it was a securities offering. The Ripple selling its tokens and continually selling its tokens was an unregistered securities offering. I think I concur with that. I just thought the case was going to have a lot of problems, and a lot of that dealt with the very specific rules that apply to securities class actions, and something that is probably relevant to maybe only 500 attorneys in America who do this stuff. So I won't go down that. I was pleasantly surprised, however, that the case has been allowed to proceed, and that the court, when I kind of read the opinion letting the case proceed and denying the motion to dismiss, that this, again, judges are looking at these projects from 30,000 feet, that you have an investment raise, what is very analogous to a traditional investment raise. And they're saying that they're not going to get caught up with the very overly nuanced procedural arguments that I think a lot of lawyers want to hang their hat on, especially in federal court. So I'm pleased that the case has been able to move forward. I think that Ripple is one of those steaming piles of poo, and I'm probably going to get hated on in the troll box. I think I'm going to get hated on probably in Twitter as a result of this. But Ripple is just, it's nonsense from my perspective. And there's things that are based on confidentiality agreements that I can't discuss that are very negative about the internal workings of Ripple.
Yeah, well, you don't need to go there. Like, thank God for the internet and all these old screenshots of Ripple, basically with statements on their website saying if the Ripple network grows into a vibrant distributed payment network, Ripple Labs will have accomplished its goal, and Ripple protocol. No, wait, that's not the one I wanted to read. It was like a lot of stuff here about it straight up being a
money, right. Like flashing
Ripple
lights
Labs
and come
committed.
make all the riches.
Yeah, and like the whole giveaway thing, Ripple Labs is committed to giving away the majority of the 100 billion XRP in existence to a large number of people. They are, started distributing XRP to early adopters through a variety of giveaways and promotions. Click here to learn more. I got all these screenshots. Like, if I'm ever called in as a witness to talk shit about Ripple in court, I would absolutely do it for free. Here, we will be giving giveaways. So speaking of Ripple giveaways, so someone actually decided to make these Ripple giveaway videos and post them to YouTube, and Ripple is not very happy about it. I guess that's the next case. And Adela, let's welcome you to the show. And then you joined us right on time to talk about Ripple. How are you?
I'm good. How are you?
Good.
I've been listening in, and I very, very much enjoy the arguments going on. But yeah, good to be here and happy to talk about Ripple, because this is one that kind of like bugs me a bit. So.
Yep, and let's go back to screen share. This is another screenshot. God, I have so many, and a lot of them have been trying to get scraped. Ripple's been trying to get these off the internet. Like, here's a straight up statement from the Ripple website back in the day. Said another way, we will engage in distribution strategies that we expect will result in a stable or strengthening XRP exchange rate against other currencies.
Yeah, that's not good.
Yeah, no, it gets worse. Like the direct statements by the CTO. But this is the security side of it. I kind of want to talk about the giveaway side of it. Ripple Labs plans to retain 25% of all Ripple to fund operations and hopefully turn a profit, and distribute the rest to incent the participation of market makers, giveaways, and consumers to utilize the protocol. Given that there are finite number of Ripple, and by the way, there's absolutely nothing keeping them finite. That is their option. As demand for Ripple grows, the value of XRP should appreciate. Like, these are the kinds of things I really hope that case against Ripple being a security are being used in court. In this matter, Ripple Labs believes that its incentives are aligned with those of protocol's users. Both want the protocol to reach its full potential and scale. That should not go well in their Ripple case. I can show a lot more, but I can show direct statements from the CTO and probably CEO as well. Like I said, I got a decent amount of evidence here, just in case something ever comes up. But in the meantime, now that Ripple has all of these billions, that they printed out of thin air and then pumped them. We have these videos popping up all over YouTube. So if I just go to Bitcoin, or I could just go to Ripple giveaway, but we can do Bitcoin giveaway YouTube, and you get them. And right now they seem to, if we just go to videos, right now they seem to be very popular with Shatran. I guess I should just go to a YouTube channel, YouTube Bitcoin giveaway on YouTube. So all these Bitcoin giveaways, and I don't want the audio to go. I don't know if this is the one I was looking for, but the other day I was watching Shatran, the Canadian hedge fund big investor guy, and in that case, let's do a Bitcoin giveaway. I don't know if this one is it, but I think if we search directly on YouTube, they show up. I mean, sometimes they're not streaming, but when they stream, they have like 100,000 people watching them. And here it is. Yep, Wozniak and Jack Ma. The other day it was Shatran. This is the one. These are the ones that are happening. This is from last week. This is live right now. Jack Ma interview, and this is nope, only 10,000 people watching. Definitely not it. So these guys, and if you click on them, they're straight up scams. Is very like, oh, this is people talking about it being a scam, and prominent people are getting caught on this. These are the scam alert videos. Anyway, I'm rambling on. What is going on? Have you guys looked into this lawsuit? And I find it ironic that Ripple has to take this fight and YouTube is not doing anything. Or like so many scammers. I have imposters on Instagram and Twitter and the gram. Every time you send a tweet, buy the gram token bots are all over it. It's very frustrating. Anyway, I'm gonna shut up. Who wants to go first on this? Anyone? We can talk about Ripple being a security. It's been, I wanted to do
I think we're all scared to start after the last one because they'll be like releasing the dam. But Adela, I feel like you have something to say and you're kind of happy that this one got called out. So why don't you start?
Why don't you start?
No,
I'll jump in.
I choose you. I choose you. I feel like I talked too much last time. You talk. Come on in.
Okay, so I kind of glanced at the complaint and I read some language and notably, the court should compel YouTube to fulfill its legal obligations to continue its policy of willful inaction and to prevent further irreparable harm to Ripple's brand and Mr. Garlinghouse's reputation, which in turn will prevent further financial injury to the individuals who are duped by the scam. Absent a court order obliging YouTube to act, the scam will undoubtedly continue to flourish and create countless more victims, the suit said. Okay, so then I looked a bit at YouTube's blocking policies. And one of the things that kind of stood out was that they can block for a couple of reasons, including criticism of a ruler, Google, government officials, religions, religious leaders, national laws like copyright and IP, protection laws, violations of hate speech, and a whole bunch of other things, pornography and all that. What was really of note was that, you know, the content would be reviewed by staff. And so that's where the big sort of the big questions are raised for me, because I'm thinking, if this is it doesn't go into more detail about what that review process is. And so I feel like there's a lot of space for someone or the staff, you know, to take advantage of that process. It's just a lot of power, and we don't understand how that is actually being carried out. And I think it's quite harmful. Tone, for example, wasn't Tone banned for a while?
He stepped away.
Channel taken down.
He got like a 24-hour ban, and then it got reversed. Tone, you're back.
Yeah, so I was banned for about a day. Now, the reason why I was only banned for a day versus other people that have been banned for months is because I had the community support to kind of yell and scream at YouTube, and they reviewed my channel. And the explanation that I got over Twitter, nothing official, was that my channel was mass reported as being harmful and dangerous. And it was removed due to probably the Ripple brain dead or army of the brain dead. So most likely. But in this case, like there's just so many blatant scams that just continue to happen on and on and on. And like, I don't understand why it's so difficult for YouTube to actually get these algorithms right and ban the scams, but not the actual channels.
But do you see how slippery that is, though? I mean, do you understand like how a review process by staff that's not very well defined is an issue here?
Well, of course.
Right.
Which is why I'm the one that was like the least aggravated when my channel was banned, because I knew that my channel did not deserve to be banned. So it was just a matter of time. But yeah, so I mean, I understand. I never really complained about YouTube all that much.
But there's a lot of YouTube stars, I'll include you in that, who, especially on the political end, who are getting banned. They have a community, but they never come back. And our ability to perceive what's out there is getting more and more limited over time, regardless of whether you agree with these people or not. And
I know, but that's
I find
bad.
it sad. I mean, they're all going to BitChute, and it's hard to follow them around.
It's bad YouTube policy, of course, but is Ripple really the company to fight on our behalf, considering they're in the middle of a securities lawsuit?
Well, I mean, they kind of have to, or what should they do?
I am of the mind that regardless of what you think of the merits of somebody, whenever that litigation brings up some secondary or tertiary issue which expands and protects the law for everyone, you don't necessarily need to object or hate the person that's defending the suit to appreciate the fact that the concept that they're arguing could benefit everybody. So,
I agree. But at the same time, the money that they're using to fight this is coming from gullible investors in the Ripple token.
be that
Well,
as
I mean,
it
that's
may,
a totally different, you know, what's really germane to everybody's life is how YouTube is responding to an allegation that something is a scam or an allegation that some statement is harmful, right? Because we're really talking about from a macro level, and I think I absolutely agree with you, Adela, is that this is an extremely slippery slope. And I would always.
I was gonna say, let's save the Ripple. Let's save my hatred of Ripple for another day. Let's talk about the merits of the case as you're proceeding, as I interrupted. Go ahead, Bill.
Well, I don't know about the merits of the case. I mean, this is something that we all need to live with, right? We're creating a society here where these tech giants have power, right? They have power to decide what goes on their platforms. And, you know, we've seen all of the arguments for and against it. I have to be honest, you know, I want to be this warrior for civil liberties, because that's really where, you know, my heart lies in a situation like this. It incensed me terribly when I see people getting banned for, let's say, a political opinion they have, whether you agree with that or not, or whether things that are distasteful should be banned as hate speech. I think things like that are very dangerous. This is an interesting situation, though, right? I mean, you're dealing with scams. Should people be allowed to blatantly use so if I'm YouTube, right, should I blatantly allow someone to conduct a scam on my platform? I don't think that I should be.
And so that's what I'm talking about, Bill. That's what I'm talking about. You know, this arbitrary review process, right? So Tone gets banned, and you're telling me 100,000 people are watching a channel on an obvious scam. Like, I've watched some of these. They're so obviously scammy. You know, there's not even a question about whether they're a scam or not. And nobody You're
I
telling me
agree.
that no
Tone
electric
shows are
board-
all scams.
I think the amount of times he actually says scam, the bots pick it up, and then it just automatically gets tagged.
The slippery slope is YouTube or any other party making a subjective determination that somebody's content is a scam or is unlawful without some sort of determination from the court. And
well, there should be laws, right?
Right.
We have laws that prevent scams. I'm not saying there should be laws. I'm saying that there are laws. We don't need to make up new laws for YouTube or have a YouTube committee that decides whether something is harmful or not. There are tests under if you're looking in the US, under what the elements of fraud are, or what the Federal Trade Commission Act for false and misleading advertising, or what constitutes language that is, what is that test under the First Amendment? It's the whether it's going to imminently cause someone harm.
Clear and imminent danger.
Clear and imminent danger. So we have the laws that can establish the framework for this, and frankly, I think they're really good laws. I don't know why
except the same people that interpret
companies,
those speech laws are the ones that have come up with this amorphous gray area subject matter called hate speech, which doesn't actually exist, but they enforce it. Right there, and that's the problem where we face with the interpretation of what content of speech is acceptable and what isn't. When you go back to Justice Marshall's, was it Marshall? No, it was State v. Cohen. One man's lyric is another man's vulgarity, right? When you compare speech components to that, and you compare, somebody's claims, oh, that's the most awful thing on the planet. How the hell can you say that? That's terrible. And another person says it's absolutely beautiful. But the only person that decides is a committee at YouTube that doesn't want to offend people left or right and decides what's going to be.
Well, because
because
they
terrible.
have business considerations that go beyond what the First Amendment, for example, is designed to protect.
So the question then is, have we got to the point to where YouTube, and the only way this matters, where a First Amendment defense matters, is if YouTube has now been sufficiently determined to be a public forum where public forum speech rights exist. If that's the case, then YouTube can't censor anybody. But if they're not a public forum, then they can determine whatever content they want, right?
I mean, I wish I was a civil rights lawyer so I knew more about this. I deal with securities and finance and corporate governance, right? So take all of this as a grain of salt. But I know what kind of society that I want to live in, and I want to live in a society with more information and with more viewpoints. And there's going to be, there's a bell curve of thought, and there's going to be assholes and extremes on the ends of that bell curve. And they're always going to be there, and you can never get rid of them. And it's better that we have them out in the public forum where we can point our finger at them and say, look at that asshole over there. And look what an idiot they are, and let's ridicule their opinion, and let's ridicule the statements that they make, instead of driving them under the ground and pushing them off into the dark corners of the internet where their ridiculous opinions can grow and foster. Now,
yes, you may recall from probably your second year of constitutional law, second year of law school, where you were studying free speech, and one of the basic tenets of free speech is that to allow free speech and to allow political speech and allow people to say what they have on their minds is what they call the fundamental letting off of steam. To allow people to have their free speech and to be able to voice their opinions, especially political speech or things that they're passionate about, to be able to allow those things so long as they do not cause physical harm to anybody else or do not incite physical harm by somebody to somebody else.
And that's a great standard.
That speech is protected, and that's the law today.
That's a great standard.
Which
then where does
but YouTube? I mean,
financial harm?
Jason, I think you're getting to this. YouTube is not the government, and it's not a public actor. It's a
but that's the thing, is that we have had forums. If you go back and look at your common law books and dust them off, we have had scenarios where traditionally non-public forums have become public forums through public adoption and use of that and consent of use of that, to where the street corner or the town square was your protected area. You have had other areas that have become de facto public forums where speech is protected. And that's why I asked the question of whether or not YouTube has transmogrified into that public forum environment to where those free speech expectations exist today.
I get it.
I think it's very clear that they do.
I wish that was the case. You know, I'm a common law fan, but I don't think they qualify under a common carrier. There's, for better or for worse, those alternatives, lots of them, Vimeo, BitChute, and the popularity of the platform is, to bring up the word we're trying to avoid these days, it's utility and it's first mover advantage. It's not a monopoly in the sense that it doesn't crowd out other platforms. So
it's very clearly a monopoly.
Well,
I think there's market power.
Because
there's definite market power.
Well, monopoly, not through oppression of other competitors, but by first mover and being popular, and the network effect.
But let's use Tone, for example, as an example of what we're talking about here. Now, Tone, you have essentially put your business on YouTube and Twitter. Okay, you have set out to create a vast, I mean, I don't know what the value of your brand is, but I mean, you've got tens or hundreds of thousands of followers. You monetize that. You've spent tens of thousands of hours to invest your business on this platform. And I think that it is, and I don't know what legal box you put it into, but I think that wrong is, you put it in the box of wrongful conduct to arbitrarily and capriciously deny people that forum that they have built their business on, paid dues and monies, probably as portions of your advertising revenue to YouTube, and their ability to just cut you off. I think there are legal mechanisms for specifically people like you, Tone, to challenge this type of behavior. I don't know what it is.
Some kind of quasi-contract argument that there's a obligation build up over time?
We have similarities in public forums where you have a public town square and you want to be able to conduct business and you want to have free speech. And within conducting that business and free speech, and everybody knows you're going to make money from ticket sales or from viewership, et cetera, but you still have to apply for a permit in that town square to set up that stage for that day. And to the extent that Tone is paid or pays money in order to have a venue where he's making money, that doesn't negate the fact that it's a public forum. That mirrors and mimics the same extent that cities or counties or municipalities charge for access to their city maintained public forums later on. For example, when I lived in Portland, if I wanted to go into Pioneer Courthouse Square and set up a stage and have a concert where I was going to charge money, I had to get a permit from the city of Portland in order to do that. Just because you have to pay money or money is involved within a certain platform doesn't negate the public forum nature of it.
So are you making a First Amendment argument?
Yes, absolutely.
How can you get there if this is a private actor? They're not a common carrier. There's not generally public access given when it comes to publishing videos. You know, the normal thing.
No, hold on. Anybody right now can click on this YouTube link and watch this for free.
Watch, but not publish. When you publish, it's under terms and conditions.
No. Sure, but there's to the extent that they suspended his channel before, he couldn't publish to his channel. Merely having the live performance and or a replay of it. Sure, you want to take away one video because its content breaks something, but shutting everything down.
Well, that may be injudicious, but why is that not contract? How do you get to the First Amendment if they're not government?
Censorship, and to the extent that I talked about before, and asking the question. I'm not making a declarative statement. I'm asking the question: has YouTube reached the legal equivalency of a public forum accidentally?
You're not.
I don't know. Okay, so let's ask Tone this.
I wish that was true personally. My opinion is.
What happened to Adela? She did I interrupt her too much? God damn it! I'm sorry.
But Tone, really though, what is so? Let's talk about what are your reasonable alternatives to reach an audience like yours. I don't think there's a forum that is separate from YouTube that you could actually monetize and use to create your business. Is that right or no?
Well, yes and no. Like, here's the thing. Like, people ask me, like, what would you do if your YouTube channel was banned? And you appealed and they said, nope, we're keeping it banned. So my solution would be, well, one solution is I'm not going to do any more YouTubes, because the challenge is rebuilding the brand on another platform, because now I have to choose a new platform wisely. And there is no single platform that can compete with YouTube. But in aggregate, all the other platforms combined can compete with YouTube. So my recourse would be to now create accounts with every possible streaming mechanism. And I think this is the future, by the way, of streaming. The future of streaming, due to these kinds of actions by YouTube especially, the future is going to be the following. People are going to use more restream services, where the next time I stream this law show, it actually streams to a dozen or more than a dozen streaming mechanism. It will stream it at the same time to Twitter and Instagram and Facebook and another YouTube channel until that gets banned. And so basically your brand no longer becomes a slave to a platform. And if one platform gets banned, fine, I'm still streaming on 19 others. And people and you're growing your brand across all the platforms based on whichever platform a person likes to watch you on. Now, these things at the moment are like, if I was to start a new channel, that's what I would do. But each of these streaming platforms, they're all completely different. And you have to learn, like right now, I'm not really in the mood to start learning new streaming software and how to actually do that, open more accounts. I'm being lazy. My audience, 99% of my audience is on YouTube. There's really no reason for me to invest my time, my initial time and money investment to stream across many platforms. But if I didn't have
so
YouTube,
if I was okay,
that's what I would do.
So if you were talking about an antitrust case and you had that testimony on the stand, I think that's very compelling that YouTube. Now, what are the negative effects? Because antitrust is really focused on a very narrow issue. But I don't. But I think the concept in an antitrust case of market power is very analogous to the de facto public forum argument that Jason is saying, because the conceptual framework of have you become a public forum that everybody relies on you, that there's really no alternatives, and if you want to speak and you want the world to hear you, you have to go here. And I think that the law, whether we put it underneath the First Amendment or we put it underneath a contract, some sort of a reliance, or we put it under some concept of market power, I think the law is sufficiently broad to handle this situation, and we just need a creative attorneys, frankly, to think about it. I'm not advocating to sue YouTube or any of these other, Twitter or whatever. But at the same time, everyone now who speaks on one of these public forums is subjected to the fear that if they say the wrong thing, they're going to get banned. And that is a really dangerous, it isn't good for society.
And a while ago, sorry, Josh. A while ago, we talked about this issue when it came to, what's his name, the guy from your state, Jason, Alex Jones, where he got banned from like 3 different ones at the same time. And
We're
he
all
was
Alex Jones.
Do not associate me with Alex Jones. I just want to say that right here and there. Don't associate me with that guy. Just...
But okay, isn't that the thing where you want those guys to let off steam, and you want, it's the Overton window. Once he gets banned, who else gets banned?
I have no problem.
Don't you need to defend speech at the bloody borders?
I have no problem with people letting off steam. I have no problem with people speaking their mind.
Turning the frogs gay.
If you want to fly a Confederate flag, go for it. It doesn't mean I'm going to fly a Confederate flag or I want to do it. But if you want to do it and you want to signal to the world that you're some racist asshole, that's your right to do it. This is America. You can do it, but it doesn't mean
we all get to point our hateful fingers at your hateful fingers, and
and we're done.
But just because
and here's the thing, just because I think that that's okay to do doesn't mean that I agree with the message. And that's where I think speech in the United States has lost track of reality, that saying that asshole gets to be an asshole and say asshole things all day long. Defending the ability to do that means you're defending free speech because you're defending some other guy's ability to do that later on. It doesn't necessarily mean that you identify or approve of the message. So
that's right.
Don't associate me with Alex Jones, but I do and would defend Alex Jones's right from here to the day that I die to be able to say whatever the hell he wants, absent inciting violence upon somebody else.
Right. Oh, I'm with you. I was just making a joke. You guys are from the same state. Sasha, I cut you off.
Oh, one of the weird things about YouTube too is the shadow banning. So I've heard a lot lately, like the show doesn't actually get taken down, but it has no views. Like if you look at Josh Sunderson from World Alternative Media, he's always showing like sometimes his views are in the hundreds of thousands and other times they're like in the hundreds, and there's no accounting for why certain shows, it's just this algorithm that, you know, will put something into getting views and others don't. And when your income relies on that, it's not a fair, you know, it's just not fair that you can't get your message out, even though you haven't done anything worthy of getting completely banned. You haven't violated the terms of use to a standard where they say, okay, we can't show this, but they, you know, in the back end are, you know, making it so that people aren't seeing it. So I think that's something.
But if you do it in a secretive way like that, it's almost an admission that it's wrongful, right? Because if it was, if people were actually going up towards the line and crossing the line of either what's improper under their terms of service, which I think, you know, I get there's legitimate reasons why, you know, for example, YouTube would not want to have a Confederate flag, for example, on its platform, or that it wouldn't want to host a scam. It wouldn't want to like have a hex video. So I can get that, but the whole concept of saying that we're going to shadow ban people, I think that's particularly insidious, because if there was a really good bona fide reason for what they were doing, they would do it in the open. And they would cite specific either laws or aspects of their terms of service.
Yeah, stand up and do it.
What did I miss? Did you guys talk about Alex Jones? Because that's what I want to talk about.
Yes, we did a little bit.
This is going to get this banned. This is going to be the most banned episode of Bitcoin Law Review.
Right.
He who shall not be named. And I think that's scary. I think that's really scary. I don't agree with Alex Jones either.
No, I can't. Like, he makes me cringe. I mean, but I think the mark of a civilized society is that we have to tolerate things that actually exist. And some of those things, that means people have opposing views. And so, you know, he talked about a lot of things like white genocide, and, you know, he was an anti-vaxxer, and reptilian people, and, you know, Hillary Clinton, and that triggered a lot of people.
Class A asshat, right?
Absolutely. So this
isn't that perfect as a
right?
Isn't that perfect to defend First Amendment with? And I'm not being sarcastic. I mean, that is the rampart. Actually, beyond him is a rampart. You know, and
that's how you test it.
By the time
it's the Alex Jones test.
Kind of.
The thing is, you know, YouTube is a private platform. They can, you know, pull anything that they want, any kind of content that they want to, really. But I think that what we're creating is a society that's increasingly just moves on trigger values, where we don't like this, so we're gonna pull it. And I think that's why Alex Jones was ejected from their platform. It's because he had contrarian views, and people don't like that. So,
But he wasn't just ejected from YouTube. He was ejected from basically all of them
oh
simultaneously.
yeah, he was just
He was-
blacked out.
he had banking and payment platforms have, and I don't know the details of this, but I mean, it's, from what I understand for Alex Jones, it's gone pretty far down the rabbit hole that
It's dark.
scares me.
It's really dark, because they literally they just depersoned him. Like he doesn't,
They depersoned him.
they depersoned him. And
Yeah.
I think the terminology is called
Right,
cancel
Matt,
culture, and Alex Jones has been canceled.
Canceled.
Yeah.
right.
Did anyone?
I mean, Adele's thing was like, you know, he became an unperson. Like it's a picture of Stalin where his commissar disappeared in a later version.
It was a real tactic from real oppressive regimes, and just because these tactics are being used by private companies doesn't make them okay. Okay, history has examples of what happens when you silence people, when you silence dissent, when you push people underground. It's dangerous and it's not good for civil society. We've had hundreds of years of experimenting with what type of society creates the most beneficial world that we want to live in. We've had dictators, we've had kings, we've had monarchs, we've had Hitlers and Stalins and Maos and Pol Pots, and they're terrible examples. And the examples of the strategies and techniques that were used by these dictators are being adopted in modern day by private corporations, and it scares the shit out of me.
That's exactly what I was
Scare the
going to
shit
say.
out of everybody in the world.
It should, and I was going to say that it's reminiscent of, you know, those regimes burning books and erasing music, and just
Book burnings,
entire histories, and so that's what's been done to Alex. And
or are you talking about editing the original Dumbo to exclude the crows on the electrical wire because it's offensive?
Well, let me ask this to the group because I don't have a good answer. If we sort of surrender momentarily the idea that YouTube is a public utility or public forum, just suppose we can't go there. What alternative strategies can be deployed to preserve the full range of conversation?
Bitcoin.
I don't have the answer. I want to know what you all think.
Well, there is Bitcoin, but I think for those platforms that they should be held to what the standards of the laws are in the United States.
Right.
They should be held to the FTC rules for false and misleading advertising, and they should be held to the actual and imminent danger standards. And they already have a pass. See, this is the thing.
I agree.
They already have a pass under Section 302,
right?
But they already have a pass under Section 302 that they're not liable under the law for the things that people say on their platforms. Okay, they've been given this exemption under the
I'm sorry, I know it's a classified ads thing, sort of.
Yeah, so I mean, they want to have it both ways. They want to decide what they can put on their platform and be a publisher and be an editor and have editorial authority over their platforms, but at the same time say, well, you can't sue us for anything that we say or don't say on our platform.
Right.
I think that you know, the law doesn't, that their terms of service and their policies don't need to go beyond the law of any particular jurisdiction that they're in.
Well,
Bill, this is on point, because what you're saying is super on point, because and this is from their policies: preventing criticism of a ruler, Google, government officials, religion, or religious leaders. Like, what does that mean? Like, what law is that from? You know?
Yeah.
In some countries, I'm sure there are laws,
Mostly
right?
law.
If you go, so, you know, this
Well,
is
in
another
Thailand,
thing.
they
If you
got
have
lese majesty.
multinational-
You can't insult the king.
Not in the US of A, though.
Well, they're a US company, and you would hope that they would try to export their values to the rest of the world, because frankly, we do a lot of shitty things here in the United States, and we have a government that is a bully around the world, but we have a kick-ass legal system, and it's the best that's ever been tried. And now we're getting in this world where there's a brand of thought that says that the CCP, communist authoritarianism, is actually a better mechanism to organize society. I think that we see there's a lot of cheerleading of that. I think that's extremely dangerous. And we're seeing it. We're seeing things like the CCP's social credit score coming out and being adopted by US tech companies. And that's, you know, I used to live in China. I love the Chinese people, and the Chinese culture is a wonderful thing. And there's a lot of China hating that's going on right now in the United States. And I think that it's very unfortunate. Having said that, I lived in China about 20 years ago. And it was very disheartening and scary for me, the way the CCP was able to exert authoritarian control. And that was before they got all of their technological capabilities with cameras on every street and facial recognition and monitoring things that go on inside emails and apps and things of that nature. And that's not a world I want to live in. You know, my wife is pregnant. I've got a baby on the way, and I don't want to live in a world where we can't talk to each other. And we need to worry about what we say.
Congratulations.
Thank you.
Congratulations.
Yeah, we have.
Well done.
So this is one of those things that comes up to the top of my list lately, because the world is changing very fast, and liberal democracy and individual civil liberties are under threat worldwide. And people need to be very cognizant of that, and not just you know, lay back in the bathwater, the warm bathwater, and slit your wrists and just slowly drift off into oblivion. Because once these are gone, they don't come back.
Right.
And once you have a complete totalitarian surveillance state that is ubiquitous, that monitors the things you say in your home, on your phone, and in your office, and in your email and in your text messages, if you ever want to fight back against that, humanity can never fight back against that, because you won't be able to organize. So once it's here forever. And nobody's having that conversation. It's a very important conversation for the world.
We're having it. No, we're gonna have it now, because this was on my list. We're gonna skip some of the other crypto stories, including EOS.
This is a natural segue.
You need a whole show on internet censorship. I mean, I'm actually chatting with someone who's kind of censored right now on Telegram, and he's watching you and kind of taking encouragement from this right now.
Can we look? I'm happy to do another show. I actually tweeted out. Is this that tweet of mine? Right. Like, I tweeted out some old cases, whether this whole lockdown is or isn't constitutional. And I think this has a lot of those. Nope, that's not it.
That's something else.
We'll see where that one goes one day. But
John Seth would be a great guest for this topic too. He's really passionate about free speech.
Who would be?
John Seth.
Oh, John Seth. Yeah. So I'm not sure where that link went, but
don't do a show entirely on this.
Mm-hmm.
Yeah.
Look, I'm gonna drop a bomb into this conversation.
I found it. State quarantine powers under the Constitution in the fear of the Ebola. So this was I posted it in our law show. Sasha, I know you read through this, and I do want to talk about it some more, especially now with the bill being voted on, that the FBI can just look at your web browsing history. I mean, it is getting out of control. So Bill said a lot of thoughts. Anyone else want to take the floor and just, you know, say it? But we will do an actual show on this.
Well, so I'm in a chat with some of my law school friends, one of who has become an FBI attorney, and two of them are prosecutors for the state of Florida. So we often have debates around the overreach of government. And anyway, I sent that Vice article about the FBI to them, and it was torn apart. Like the Vice didn't actually do the best research job. It's really skewed. What they got wasn't quite, you know, as the headline would say that it is. They still do need a warrant, but there's it's like that imminent, the way I understood it anyway, is that it's like that imminent danger thing. If it's a terrorist, which, I mean, the same with all the financial stuff, is if it's a terrorist, you know, you can do anything you want. And that's kind of what this rule was. If it's an imminent danger of terror, they can go and look, but they have to, even then, get a warrant after the fact to show that there was an imminent danger. So she said the resources of the FBI are really, I can't believe I'm defending the FBI here, but she said they're stretched so thin that there's no way that they're actually monitoring, you know, every normal person's web browsing. But I mean, that's
well,
not.
they may not be monitored by a person, but they're being recorded in perpetuity. And there was a,
an
there was
algorithmically
a,
search at any time. Like,
yeah, what was,
you know.
there was a place that was built out in the Nevada desert a couple of years ago. Did anybody know what I'm talking about? And it was basically
the huge
designed,
data center, the listening post.
NSA, the giant NSA data center.
the giant NSA data center that was designed basically to suck up all of the communications from everywhere in the world and keep it forever. So whether or not any particular arm of the US government at any given time is pointing a finger at someone and monitoring something, the evidence is indexed and it's there. And I don't remember this. There was a famous quote by Stalin's chief of police, and he said, "Show me the man and I'll show you the crime." And when you create a society with laws that, you know, are so labyrinth like we have in the United States, and you have an ability to record what everybody does all of the time, you create a society where you can point the finger at anyone at any time, and you can criminalize someone, and you can point the awesome arm of the criminal justice system against an individual. And that's,
I want to point.
This
point
is
out,
dangerous.
I want to point out technologically that this is a very dangerous, slippery slope, because what this bill allows is for warrantless searches, not of your computer, but of your internet service provider's history of your search and history, which means anybody that walks into your house that you give your Wi-Fi password to is searching from your originating IP to your ISP, and that information then is logged as your search under your contract, and it's not differentiated whether it came from you or the neighbor that may get your password or your kid that's on some rant or anything else. Who knows who's searching what? So you, as the owner of the internet connection for your home or your apartment, are now subject or believed to be the person that's actually searching anything and everything, and is held responsible for anything and everything that's coming out of your DMARC router. And this becomes so ridiculous that I can't even fathom the consequences of having to defend why you know, somebody went and visited some website, and you're looking at the claim and you're standing in court saying, I have no idea who visited that. And the presumption is you did visit it because it's your contract, your ISP came from you, and you're the guy that's on, or the girl that's on the contract. And you have no idea who's done it. So
can't they look through the camera on your computer almost all the time anyway and know who did it? Like, but the other side of that too, what if they plant like child porn on you? You know, we know that police have planted drugs on people many, many times in history. So, you know, now the new thing is they can plant any kind of stuff in your web browsing history and charge you for it if they want to. And this isn't new either. If you don't delete your Gmail your emails after 6 months, they're property of the, you know, of the government. Like, they're allowed to search them. There's already
think about this. All of us that use incognito browsers, that doesn't mean a damn thing, because the ISP still has the records of what's gone to your demarked point and not. It's all based on that origination. The only thing an incognito browser does is it doesn't track browsing history on your computer. It has nothing to do with the ISP that's funneling the requests going back and forth.
You need a Linux virtual machine over VPN.
VPNs.
Your MAC address.
That's it.
And that's like a
creating,
Yeah.
we're creating this turnkey totalitarian society, right?
Yeah.
We're creating a governmental structure and a system of laws and exceptions to laws and exceptions to the Constitution that allow ridiculous violations of civil liberties that, at least in the United States, and by the way, we're the only country, Preston Byrne, if you follow him on Twitter, really goes down this this rabbit hole very well, is that the United States, for example, our First Amendment and our Fourth Amendment. First Amendment is right to free association, speech, and religion, freely assemble. The Fourth Amendment is right to no unreasonable searches and seizures. These particularly are unique to the United States, and they protect us. They protect us from
debatable. If they still
they're supposed to protect us, and they're
Yes.
they're only one generation away at any given time from being gone.
Yes.
And every generation who is here in America needs to stand up for these rights, because if we don't, our children and our grandchildren are going to live in a techno surveillance state that is just mind-bogglingly terrible. It's going to be terrible, and it's already happening to a certain part of the world.
Yeah, no, I'm with you. All of those amendments are like merging into one that will say all Americans are equal, but some are more equal.
I got to tell you, when it comes to my smart refrigerator, I don't want the government to know how often I order cheese and butter. But because my smart refrigerator is telling me that I need cheese and butter, and that's going out onto the internet, now the government knows when I need cheese and butter. How ridiculous is this entire surveillance thing? Get a goddamn warrant. Without unreasonable search and seizure, we have a basic right in this country to be free of unreasonable search and seizure. Where is the reasonableness for the government carte blanche to be able to look at what anything that anybody does?
Yeah, and Jason, well, what about that Carpenter case too? Remember, like it was the summer of 2018, the Supreme Court, so they held off Ross Ulbright's trial, saying we're going to decide this Carpenter case first. In the Carpenter case, they said in order to search a laptop, you need a warrant. And then it was in order to search a cell phone. But then this, whatever that Vice article said, it just completely overrides the Supreme Court rulings. And that seems like what keeps happening. Like the court is losing their power.
Guys, I hate to do this. This is like my favorite topic.
Yeah.
I like with AMJUR.
No, we're gonna do another show. We're gonna wrap this up, guys.
I got a 3 o'clock. I got to jump on. Can you?
Yeah, I'm looking at the clock too.
Yeah.
Can you please do a show dedicated to alt tech and First Amendment, please?
Yeah, let's do it.
Let's bring Jen Seth on for that one too.
Yeah, we should.
All right, guys, I got to run. I'm late for my 3 o'clock. But
all right.
Cheers.
All right. See ya. Bye, Gordon.
Pleasure, everyone.
I'm gonna jump off too. Bye, guys. Thank you.
I got a bounce in a
Sasha.
sec, but it's exactly what Jason was talking about. Like these functionaries must act under the rules that they're supposed to act under, and if not, it just chips a little bit and a little bit and a little bit at our entrenched and enumerated rights, and suddenly everybody starts adopting the use of VPNs. Everybody's using VPNs, and suddenly use of VPNs are banned. So it's
right. Do you see that? That's more of a question for Jason and Bill. Do you guys see the possibility of VPNs being banned?
I don't want to comment on that right
know.
now. I'm not in the right headspace. I may end up needing to put on an aluminum foil hat if I go down this road anymore.
guys,
No,
I gotta bounce because I gotta
have
go
my
call
tinfoil
Sasha.
hat. It's ready.
So-
It's
All right,
my briefcase.
bye guys.
Bye.
But we should do a show on this, really.
Yes, and hey, look up the constitutionality of this quarantine. I really want to talk about this.
Oh, I have like a ton. Listen, I have a ton of notes on this because I like.
Beautiful.
Seriously, and I wanted to ask Bill about something called a rational basis review. Anyways, I gotta go though.
I wish I knew more about it, but we'll talk.
That's your
about it
jam.
next time.
That's your jam, though.
Hey guys, post links in our chat, and the next show will probably be about civil liberties.
Okay, let's do it. All right, guys, take care.
All right,
Bye,
next week.
everybody.
Bye.
Bye. Cheers.
All right.
Thanks, Tom.
Bye, guys. Bill, unless you want to close us out here.
No, this is very important. I'm just going to say that this issue on civil liberties is very important. We get to make the world that we live in, and right now it's being made for us. And it's getting smaller and smaller. Individualism is going out the window in favor of corporatism. Corporatism being, the model of the CCP. And I hate to say it, I don't want to pick on China. I don't have anything against China, but you know, the people of the world deserve better. And I can't wait to talk about it next time.
All right, awesome. Hey, thanks, Bill. Thanks for coming on. And yeah, we're gonna set one of these up. I'll put together a bunch of links. We're gonna take a little break from crypto, and we're gonna do some civil liberties law because I think it's important too.
Thanks, everybody. Thanks, Tone. Bye.
Thank you, guys. All right, everyone. Thank you for sticking around for this 2-hour show. We started with crypto. We ended on a more political note. It definitely got heated. It's hard to talk about this stuff, again, on a YouTube channel that may or may not give you free speech capability. Probably not. So we got to do it all carefully. Thank you so much for watching. And I will see everybody tomorrow for a look at the price. No idea what the price is, but we're all going to look at the charts tomorrow and figure it out. All right, guys. Thank you for watching The Law Show, and see you all on the next one.